Welcome everyone. I'm Meghan Guevara from the Pretrial Justice Institute, here today for our October First Friday Forum. I can't decide lately if the months are going by slowly or quickly in our strange time warp of 2020, but welcome to October. And thanks for joining us for our conversation today on community supports and public defense. I'm really excited for our discussion. This is something that we've been talking about a lot at PJI lately, of what we can do to bolster the supports that are available in the community to help make sure that people who are facing charges are successful during that pretrial phase. And I'm looking forward to hearing what my guests, April Frazier Camara and Raj Jayadev, have to say about that today. And anyone is welcome to ask questions in the chat box at any time. We're pretty casual here on the First Friday Forum, so feel free to say hello. And it looks like we've got some highs from Santa Clara County this morning in the chat box. And we'll be taking some questions towards the end of the discussion today. But I'm going to start by inviting April and Raj to introduce themselves and tell us a bit about who they are and what they do and why they do it. April, you want to kick us off?
Absolutely. So good morning or afternoon, depending on where you are. I'm April Frazier Camara, and I'm the Chief of Lifelong Learning at National Legal Aid and Defender Association. While at NLADA, I've also been able to be the co-founder of the Black Public Defender Association, which is affiliated with NLADA. And through that work, I'm able to tackle a lot of the issues concerning the much needed systems reform that's needed to actually achieve justice, but also to be able to do it through a racial equity lens. So I'm really excited about the creation of the Black Public Defenders Association, because I think it brings a renewed focus to race that very rarely do we hear, even within public defender spaces, to talk about the fundamental issue that drives the way the criminal legal system works. And so I just feel very fortunate to be able to do this very important work through the eyes of public defenders as well. So our work is grounded in reality and grounded in the communities that we serve. So that's who I am and what I do.
Thanks, April. And I love your title. That is an awesome thing to be the chief of lifelong learning. Awesome. All right, thanks, Raj.
Hi, good morning, everyone. I appreciate being in this conversation with you all. My name is Raj Jayadev. I'm the coordinator of a community organization here in Santa Clara County called Silicon Valley Debug. And we created a community organizing model that we call Participatory Defense, which is an approach for families who have loved ones and communities who have loved ones that are facing criminal charges, and people themselves, on how they could impact the outcome of the case and the trajectory of the case to bring their loved ones home by partnering with their public defenders and their defense team, and also bringing the kind of ethic of community organizing to a courthouse, which has been essentially insulated from community pressure and community power. So collectively transform that landscape of possibility and power through community organizing of those that are facing charges, and communities and families that love them, that have been sitting on the sidelines and anxious to see how their input, their intelligence, and their activism could lead to freedom and liberty of their loved ones.
Great, thank you. And we're going to be getting a lot more into what that model looks like over the course of our conversation today. Thanks, Raj. And I'm also interested to know who is joining us today. So I'm going to pull up a quick poll question just to get a sense of who's in our audience. If you could tell us, are you an attorney? Are you a community advocate, prosecutor, judge, from someplace else? And if you don't fall into one of the lists on the survey, if you wouldn't mind popping in the chat box telling us where you're from and what kind of work you do, either as your professional role or your role in the community, or perhaps your role in your family. It looks like we have lots of defense attorneys joining us today, April. Can tell that your outreach for this event was working, but a lot of folks who also are putting themselves in that other category. So if you are in that other category, we'd love to hear from you. We have somebody from the Hamilton County Community Bail Fund, a technical assistance provider, an investigator from a defender's office, somebody from Buncombe County Safety and Justice Challenge. Welcome from SJC. Social workers, social services. So we've got a great mix of folks who are on the line with us today, and also folks who identified as community advocates, community service providers, and pretrial services. Great. Thank you so much. Glad to have you all here with us today. All right. So the first thing that I wanted to ask you about was defining success. It's been a big conversation here at PJI lately that for a long time in pretrial, kind of the triumvirate of success was maximizing pretrial liberty, maximizing public safety, and maximizing court appearance. But there wasn't a lot of nuance in those conversations. You know, when we talk about safety, safety for who? And as we know, COVID has brought up the question of safety in facilities, but those questions of safety in facilities and what it means to be safe if you're locked up have always been there. And when we talk about court appearance, what's the difference between somebody who is truly fleeing prosecution versus somebody who misses a court appointment when they're supposed to be there for a hearing? And really, what is liberty? You know, is just being released from detention pretrial liberty versus truly being released and free to move about and not being encumbered by electronic monitoring and some other really onerous conditions. So what does it look like to really examine what we mean by success and how we define success for somebody who's facing charges? So I'm interested in hearing from both of you. How do you define success for an individual who's facing charges pre-trial, and perhaps for their communities and for their families as well? And what does that mean for the work that you do? And Raj, would you like to get us started?
Sure. Well, I'm a community organizer, so my barometer of what success means, I'm kind of looking through that prism of what is transformative in a sense of power for a community that has been stripped of power in the face of the criminal punishment system. So at the baseline, success, I believe, for pretrial justice is for people to be out of custody, free. And when I say out of custody, I also mean by the extension of things like ankle monitors and home detentions, e-incarceration, all those extensions of the apparatus of incarceration that I think also is a reimagination really of caging people, particularly communities of color. So success is people being out of that cage, out of that electronic cage as well, but also with their family, their community, living the lives they should be leading, and actively being able to challenge the accusations, the allegations, and the criminal charge by being an asset, a partner, and a resource for the public defender. So when I said earlier that the litmus test is a little bit different, I think, from our perspective, certainly like the advantage of being out of custody from our perspective is that you don't have that coercive hammer that prosecutors use to force plea deals. So being out allows you to be out from under that hammer. But then for a community and an individual to take advantage of that, that means that they're partnering with a public defender, going through the case, developing defense strategies, and then showing up at court, not just solely as an individual, but as a component of a larger community that is advocating for freedom and liberation. And so one of the things that is hard to sort of document in terms of success, a lot of times people look at case outcomes, and we certainly do too. We look at, were you able to get the charge dismissed? Were you able to get the charges dropped? Were you able to get the sentence reduced? All that comes from the collaborative efforts of families and communities working with public defenders as a team. But in the backdrop of this, and in the backdrop of this really fluid moment of dynamic movement and possibility, it's also about people, families, communities of color who have been targeted, caged by incarceration, and really told explicitly, implicitly as well, that they are powerless to change the outcome of the situation. Can they, in the face of that, actually become more powerful, feel more agency, feel more voice through their active participation in their defense? So by the end of the case, not only have they impacted whether they'll be incarcerated or not, but that they are dynamic in their sensibility of having an ability to change the outcome, not just of their own case, but the idea of justice in their local community. So what we see as sort of the gold standard from our perspective for success is not only someone getting out pretrial, working with their attorney and their community to win the case, but also do they convert in their own sense of identity from someone who's a target of the system to someone that is an organizer to dismantle that system. And that's the transition we see at participatory defense all the time. I said earlier that we have this model that we use here in Santa Clara County for families and communities. But that possibility exists in every community in the country. And that's why we train organizations, community touchstones that really in the same position we were in as a community organization. We had no intention of doing court work. It was just that we were tired of seeing people we loved and cared about being taken from us and completely destabilizing our communities and our lives. And we know that there's community organizations all across the country that are similarly situated. And so we've trained them in participatory defense, and we have a national participatory defense network. I think we put the website in the chat. But that process of transformation is happening nationally, and it happens particularly in this kind of this position of the pretrial discussion.
Thanks so much. And I just wanted to ask a little bit about how that conversation happened in Santa Clara and maybe in some of the other communities where you work, where I imagine that your organization and the system partners that you work with are not necessarily coming to the table with the same definition of success. And are you seeing the needle move in terms of how system actors are defining success as a result of working together, or where are there still gaps between how success is seen from different positions in the system?
Well, it's interesting. Like, so our partners from our perspective are public defenders, but I wouldn't define them as system actors. I would define public defenders as an extension of our movement. And that's the way we calibrate that relationship. And so initially when we started, I think there was some disconnect, because this notion, like when you looked at, say, the poll that you sent earlier today about who's on the call, for the most part, that should have been, across the board check marks, where community organizations, community organizers are on this call because they're all about pretrial justice from almost a more macro level, like bail reform, sentencing reform, those kind of things. But there wasn't necessarily a place on the chessboard for a community to engage and intercede and impact this actual case. And so for years, what we found was community didn't know anything about public defenders. All we knew was the mythology of what was said about them. And that level of distrust was sort of mutual. It was two ways. I felt public defenders weren't necessarily trusting of community that they would be responsible with information to impact the case. But then secondly, community had been told repeatedly so much that they didn't have a space to impact the court decision because they weren't lawyers. And so they almost willingly sat on the sidelines and gave up control when arguably community power was most important. So it took some time for us to forge the relationship of public defenders and community. But I gotta say, once we're able to overcome that hurdle, it has been the centerpiece of all action and all ability to have impact. That's why I think that the central partner that we're concerned with are public defenders. What judges and prosecutors count and determine as success, I think would be very different. In some ways, I think they're inherently contradictory to our interests. I think prosecutors, namely, they may say that they're looking out for public safety, but when you look at their forcing of pleas, if you look at their sort of blind goal setting for conviction rates, I think it's clear that those aren't partners of the community. Those are the ones that are trying to break apart community. So our key partner are public defenders, and we'll see what our partnership could do to the rest of the system actors.
Thanks. And that's a good transition to April to hear about success from the public defender perspective.
Thank you. So, Raj, as always, you gave me a lot to think about in your comments. And actually, I want to first begin to address the question from the standpoint of a former public defender who worked alongside people when they were facing the most difficult moments in their lives. Mm-hmm. And so from the standpoint of looking at what success would look like for clients as we serve them, is to really, I'm kind of going back to the days of meeting the clients in lockup and finding people in very vulnerable spaces. Because one thing about this system is that when it comes for you hard, right? It's a very, I think sometimes we minimize, or some people refer to it as ordinary injustice. But I do want to remind people that the actual process of being involved in the system, from the point of arrest to, for me as a public defender, your first interview oftentimes being behind cages where it's maybe 30 human beings connected together in this small space. And so when you ask at that moment, what does success look like for you? Freedom is often, that's at the top of the list, as far as what success looks like for clients. But also and if you're able to get them past that very traumatic initial stage and to secure their freedom while they're pending charges, it's really an opportunity for public defenders to get clients to reimagine what their lives could look like. I would oftentimes start with interview questions where we would not start with the particular offense, but I would ask my clients, where do you want to be a year from now and 5 years from now? And that would set me up to be able to search for resources to help them succeed. And my goal was to get them to see beyond that immediate case, to remember that at some point in history that this is going to be behind them. And I think that's the role of a public defender. It's a tremendous, a tremendous job for you to come into a person's life at a very vulnerable stage and then to build a relationship to get them to reimagine what success or what their life should look like 3 to 5 years from now. And oftentimes when I engaged in that conversation with clients, they were able to identify for me all of the barriers. So now we refer to it as electronic monitoring. Oftentimes my clients would put it in very practical terms of what does it mean to go back to work with an ankle bracelet on, and everybody to see the bulge in your pants leg, and even the threat of losing your job if the employer was able to notice the fact that you're being monitored. So very practical realities of what electronic surveillance means in the life of people who are trying to survive. So success oftentimes as a public defender meant for me to try to remove as many of those barriers as soon as possible, not only for them to be able to succeed pre-trial, but for them to be able to succeed, period, in their communities, right? Like, I want to see you be able to be healthy and thriving and not to be entangled in this criminal legal system or criminal punishment system. So that is what success looked like. But one thing I really want to note is that oftentimes I hear, as the Black Public Defenders Association is pushing public defenders to deal with these very the issues of race in individual cases, oftentimes it's this thought that serving the individual client or advocating for the needs of that individual person is in some way contradictory to systemic reform. For example, if you bring up the issue of race and how a particular community is being policed to the prosecutor, you will make them angry and piss them off, and they're gonna not offer you a dismissal or some kind of alternative. So people, it's this unspoken assumption in the public defender community that those two goals are contrary to each other when we address the systemic issues in the individual cases. And one thing that I want to raise, especially for my public defenders on this call, is that that's not always true. And for the most part, based on the clients I've served, most of my clients, not only do they want individual justice for their case, but they also want systemic reform. And I'll give you an example. A client even struggling with substance abuse issues will tell you that I wish I had access to care or I had access to treatment in my community and I don't have to go across town in order for me to get access to what I need, or I have access to deal with these underlying issues in my community in my way, from a culturally responsive perspective, where a lot of the failures that we see in community-based resources for our clients, they were never built for our clients. Those community-based resources were built by people who don't have contact and connections with the communities. But the failure of those resources are pointed back to the clients, as opposed to a lens being focused on the community service provider and whether or not they are responsive to the needs. So, I think when we talk about success, it's about, removing as many individual barriers for that person's ability to completely come from up under this very oppressive system that we refer to as the criminal legal system. But also it's a second-fold question of, if you ask people who are facing pretrial charges what type of systemic reforms they would like to see, you will get the most brilliant and effective strategies that you could ever develop, because they are living it and they can give us those solutions, and it is possible for us to fight for both. So I think success, we need to really think about the ability that people who are facing this very it was traumatic just for me to stand beside people every day in the system, this very, traumatic system. What kind of systemic reform solutions can they offer, not just to the public defender, but to really rebuilding this system to actually bring forth justice?
Thanks, April. And definitely underscoring the point that people who are impacted by the system need to be part of generating solutions, because they're the ones that know from their experience what those solutions need to look like. And I also want to explore more this point of community service providers being of the community versus community being the label for anything that's not explicitly a government-run program, and the difference between somebody having a grant to provide services that are called community services versus services that are being responsive to the community. So maybe Raj, if you could speak to that a little bit, about what you feel really makes a program community-based, and what's the difference between being able to be responsive and of the community.
Yeah, I think one kind of basic barometer is, if there isn't complete compliance and participation in the community organization, is there system consequences to it? And I think that's maybe the indicator of what's masquerading as authentic community service and what is another tentacle of the system. So I'll give you an example of where that differs. So we have something that I could explain about, maybe the fuller picture a little later, but something that we call the Community Release Project. And it is really a response to what we saw sitting in arraignment courts every day and at bail hearings every day in Santa Clara, which is judges would come from the starting assumption that the person facing charges was sort of an island to themselves, that if they were released, they'd be alone, untethered in the world. And as a result of that, there were some insecurities whether they would get caught up again or show back up at court and that sort of thing. And so the response to that is to situate an individual in the context of community that cares about their well-being and their success, as April was saying. And so what the Community Release Project was doing was essentially being communicated through public defenders to say, look, my client isn't going to be alone if they're released. DBUG is here. They're community organizers. They're resources. They're connected. They could deal with the ancillary issues that come up with someone that get in the way of them getting back to court. So things like housing, things like employment, things like programming. And they could do it in a caring, loving, collaborative way, where they would be part of DBUG. They're made up of community organizers that have been situated in those same anxiety-filled moments sitting in court. So they know what's at stake and they know what it feels like. And they could, through a horizontal relationship, walk with that person through the difficult moments of their lives. And so that way they would have resources and connections to navigate the world to find some of these measures of stability that go a long way. That is categorically a very different approach. It is a community-rooted approach versus something that is like system or almost probation light, which is what I see happening cross country, where they call it a community organizing approach or a community support approach. But really what they'll say is, okay, well, if you don't participate in this class or this program, we're letting the probation department know, we're letting pretrial service know, or we're letting the court know, and then you'll be going back in jail. Having that coercive ultimatum type relationship about community involvement is not authentic or sincere community support. And it's also ineffective. When we looked at what was happening with people that were released at arraignment or at the bail hearing through our community release project support, they were people that were returning to court. We have something like, I don't know what the numbers look like, but pretty much all the time they're returning to court. And they're also using that moment to reposition their lives. And the reason why they're coming to court is because they are invested in making sure they could defend themselves against the allegation and the potential sentence, but they also know that they're not alone. That through participatory defense, through community release project, there's a community that believes in them, that's not going to judge them. There's no stigma attached to it. If anything, they're going to see this as a moment of transformation, and any of these needs that might exist that may have even fueled some of the contact with the system can be addressed collectively rather than individually. And I think what that speaks to is fundamentally, and this was what April was talking about earlier, that anxiety-filled moment in court when you don't know who else is on your side, and you look and you see the public defender, you look back and maybe no one's in the courtroom pews, and you see a judge, a prosecutor, a bailiff, maybe a jury, that is all intended on cutting your life out and keeping you in a cage. If there's a way for them to be repositioned, to understand themselves as part of a community, that it's not a solitary, individual, isolated walk, but is a collective walk, all of a sudden the odds look a lot different. So it's not just me versus the system, an entrenched system that is based on slavery, but now we have a powerful movement that makes them feel stronger as well, to the point where they feel that they could collectively bend back and maybe even defeat those institutions that are so committed on incarcerating them. So maybe that's a bit abstract, Megan. I apologize if it maybe was more value driven than practical application. But that is the key difference. And I think it's really important, particularly now when people are challenging money bail, they're looking into alternatives, that they don't create incarceration systems that just have a different gloss and a different name. Mm-hmm. For it to be community driven, it can't be consequence based. It has to be loving, and it has to be done with integrity and sincere principles.
No, that was perfect, Raj. Thank you. And I do want to get a little bit more into the brass tacks of your program, because I know there's a lot of folks who are interested in that. But I wanted to circle back to April for one off-script question, because it's come up a couple of times. But the idea that somebody who's released is better able to be a partner in preparing their own defense. What does that look like? Why is it so important for somebody to be in the community to be able to be an effective advocate for their defense in their case?
Sure. And before I address your question, I just want to build on something that Raj said about this movement in this moment in time. The beauty of his model in building community is specifically for Black people in communities of color. The only way we have survived the human experience is through community, right? That collective power is what allows us to stand against, gigantic obstacles. And so it's something about the power of that community. And I even, I see it through my work, right? When you are able to build community. And I also want to highlight, when we talk about community-based organizations, if your organization is not about transferring power and resources back to the community, then you should rethink your model. Because a part of this, and Raj talked about building different systems of, I would say, modern slavery. You don't hold people in jail, but you have surveillance. We have to be very careful that we don't recreate new forms of oppression with different labels. And I think if our models and our intentions are not centered on transferring power and resources back to community, we should be very concerned that we're just continuing and perpetuating systems of the legacy of slavery and other systems of oppression for Black communities, and not just Black communities, but brown communities, communities who are farthest away from resources and power. So I just wanted to say that. And I think I forgot what your question was, but I think from the stand of public defender, you talked about the power of being released and being in the community. I mean, and I do want to highlight NLADA. We just released Counsel at First Appearance paper through the Safety and Justice Project. And so you should read it because we talk about it and why it's relevant to racial equity work in COVID-19. Because we know, and the statistics show, when a person is able to be out in the community, just your ability to meet with your attorney, play a role in rebuilding your life, even in the interim, right? Because a part of what a successful public defender would do is to get the client to see beyond this case and to think about where they're headed, where we can begin to already work on. I mean, effective public defense, you get the client already enrolled in training programs. You set them up to make it very difficult for any judge to incarcerate them and to interrupt all of the great things that you already have in play. So from a public safety standpoint, isn't that a much better public safety model if people are immediately able to access and address the issues in their lives and begin to set themselves up for success, as opposed to being in a cage where you don't have the ability to do any of that. So, I think in the report we cite to why counsel at first appearance and release, why people's freedom is directly tied to the final outcomes and whether or not they take those guilty pleas when they know they're not guilty, or it's some issues that should be litigated. I think one of the reasons why our system has gotten to this very broken place that it's at right now is because it's designed not to allow people to fully challenge it, right? It's designed to squeeze people to have to take that first deal just to minimize the pain. So I'm looking at my hand, like if you got a hammer and you literally are hitting me with a hammer every single day inside of a cage, it's really hard for me to focus on the constitutional issues behind the stop. All of the discovery that may be out there, I could share with my attorney that they could be searching for. It's something about that, the pain of incarceration that makes it very difficult for people to see beyond kind of what am I going to do 5 years from now, and assist my attorney in making the case to the court.
All right, thanks, April. Yeah, and the fact that even outside of jumpsuits and shackles, you can tell just by looking at somebody's face whether they spent the night in jail the night before their hearing or whether they're coming from their own house coming in. It's so obvious, written across everyone's faces. And so I did want to go back, Raj, to talk a little bit more about the Community Release Project. And as you're replicating similar models in other parts of the country, what does it take to get that kind of program off the ground and to be able to build those supports in communities? We hear a lot from jurisdictions, especially rural jurisdictions, that are still heavily reliant on money bond for their bail decisions, that, oh, we can't change because we don't have the resources for pretrial risk assessment, we don't have the resources for pretrial services agencies, and really seeing that as the only two options that are available to them, of either money or something that's risk-based. And so I'd love to hear from you about how you build this, how you make it work, and what you'd like to offer as an alternative to either of those options for communities that are interested in real reform.
Mm-hmm. Yeah, I think, and that's a conversation that happens even well-resourced communities too. And I think part of it is we're situated in this false dichotomy of money bail or risk assessments. What we're saying is that there's a third lane altogether, which is community. And it should be deemed as maybe the most important resource of all, and something that exists in rural communities and big cities too. So just to give a bit of context of where that project is based out of. So our participatory defense model is pretty straightforward. All we're really doing is taking a community organizing approach that communities are very familiar with, nuanced with, know how, adept at, that is being used in every other aspect of public life. So you look at community organizing around police violence, around housing rights, around economic justice, immigrant rights. And it is descriptive, it's ancient, it's traditional in the way that April described of, it is the only resource we have used to challenge the institutions of oppression. And what we're saying is the same logic, the same math would apply if we overlaid it on top of a court system that has by design insulated itself from community organizing pressure. So what participatory defense is doing is collectivizing what appears initially as an individual experience, saying together we can do this, together we're stronger than we are alone. So what it looks like in 30 cities across the country that have participatory defense hubs that are part of the network is they have a weekly meeting of families whose loved ones are facing charges, and their loved ones traditionally are detained because they can't afford the money bail, or they've been deemed no bail because of the risk assessment or the judge's decision. And they're looking for ways to impact the outcome of that case. And they don't want to do it alone, and they're not even sure if they can, but they're leaning on the edge of their seat. They're sitting in a weekly meeting with other families that are experiencing the same things they are. And it's a half support group, but it's half strategy session. And so each week, we just had ours in San Jose last night on Zoom. They collectively figure out tactical ways to impact the outcome of the case in week-long chunks. So then they come up with a to-do list. It could be gathering material about where this person will live if released, who's going to drive them to court if they could get out. It could be about even defense information that they need to get to their public defender as soon as possible before that evidence disappears. It could be setting up a meeting with their public defender, or it might be having everyone at that meeting attend the next bail hearing together. So when that person looks back, they see a crowded room of supporters. And then they keep coming every week until their loved one's home, free, and attends that meeting. So that is the participatory defense approach. And what we found was, and this is true, I think, with the lawyers, April could correct me if I'm wrong, but the sooner community could get involved, the sooner information could be given to the defense attorney, the better shot we have of winning. Winning meaning getting the charge dismissed or reduced or impacting the potential trial and not being forced into taking that first plea. And what we found is we'd be showing up at arraignment and it felt like the prosecutors were a lap ahead, because by the time a case had hit arraignment, they had police reports, they had a prosecutorial strategy, and for the most part, their attorney hadn't even met them, much less conceptualize what a case would look like. And so we did what a lot of communities do across the country. We started doing court watch. And so we would sit in court and we had little sheets that we'd fill out with check boxes. And then sure enough, the data coming back affirmed what we experienced and knew already, was that the system was unfair, that the system was detaining people unnecessarily, the judges were biased, that they were assuming guilt just because of the charge. But telling those stories wasn't enough. I mean, everyone knows that the system is broken. Everyone knows that the bail system is broken. What we wanted to do is have some impact. And so those participatory defense families, in collaboration with the Santa Clara County Public Defender's Office, sort of created a hack to that system, which was on the first level. Now, before, I should say this, and this is similar across the country. If you go to a felony arraignment court, generally what you'll see is a public defender representing, maybe a couple dozen people, maybe up to 50 people. You might see people in the courtroom pews that are there because they're someone's cousin, someone's high school coach, someone's mom, and they're there for that detained person that has a high bail amount, but they're not sure what's going on. And the public defender has a stack of cases. That file might have a risk assessment, might have a decision from a pretrial assessment score, and then they call the case, and then they look at the charge. The judge usually, not knowing any more information, is going to decide to go with the bail schedule just off of sort of common practice and the general process that they've been operating under. And they don't know anything about the person. They don't know anything about their family, don't know anything about their community. They don't know what's at stake if they stay detained. They don't know what their future prospects are. But the people that do are sitting in those courtroom pews. They just don't have a microphone or a way to communicate that. And so what we developed with the public defenders is essentially a cheat code, which is a cheat that is about who the person is that's facing charges, how long they've lived in the community, what they're doing in their lives, but also what the person that's there to watch court for their loved one, how they could play a role in making sure that the person comes back to court or ease the concern of the judge. And so before, you'd have someone come up at that arraignment and say, robbery or whatever the charge is, judge just looks at the associated bail schedule amount, charges that, and of course it prices people out of their freedom. And then they move on to the next case, and it takes maybe 30 seconds. And that's when injustice happens, at the speed and rapidity of that pace. And they move on to the next one. But what we've done is slow down and interrupt that process. So now, once we get past COVID, because otherwise this is all two-dimensional, once we could get back into court, you're still going to see all those people in the box. You're still going to see the public defender. But before court starts, that public defender is going to turn to the courtroom audience and say, if you're here for your loved one, DBUG is in the back of the room. They're going to help you understand what's going on today. And more importantly, how your presence here could impact the bail decision. And then someone's auntie, someone's uncle is going to come up to the DBUG organizers in the back. We're going to have this form. They're going to meet a friendly face, maybe someone they know in the community. And they're going to give information about, okay, well, this person is who drives the kids to school, or they just started a job that they're going to lose if they stay detained for the next couple of days. Or someone's dad says, well, he could stay in my house, or I'll drive him to court. And then we give that sheet to the public defender, who then uses it, like I said, as a cheat sheet. So now when that case is called, instead of saying my client's name is and just reading it in a second, not knowing anything about him, can say, well, my client is here with his auntie and uncle. They're sitting in the back. They stand up and wave. He just started a job. He's going to lose if he stays detained. He's the main person that takes the kids to school. They won't have a way to get to school if he stays detained. And auntie and uncle said that they'll give reminder calls for him to go to court. So all of a sudden, the judge knows this person not as an individual stripped of a community, but as part of a community that cares about them and is invested in them, making sure they have successful pretrial justice experience. And then they'll reduce the bail, or they'll give them a non-monetary release. And that's step one. So we call that court doing, because we were court watching for a while. Then we got kind of tired of just watching. We want to do something about it. So we call it court doing. If we lose, if we don't win because of the bias of the judge or the fears of the judge that are misplaced, then we're working with the public defender to see when they're going to have a bail hearing. And we then work with that family that came to arraignment. They come to the weekly participatory defense meeting, and we see how we can prepare to make sure we tell the best narrative about somebody that the public defender can use at the full bail hearing. So they write their bail motions and make their legal arguments, but it will be supplemented by what we call a social biography packet, which is a packet that the family put together that tells the totality of who they are beyond the criminal charge. It's letters of support, it's pictures, it's certificates, it's proof of where they live, and addresses whatever the issues are that the judge or the prosecutor is trying to raise. And there's a personalized, individualized story that accompanies the legal arguments at that bail hearing that is now filled with other people, not just who is related to that individual, but other people that came to the participatory defense meeting. So again, it's a collective community approach to a legal mechanic that was designed to be individualized. And then we see the same impact at the bail hearing. We see people win bail hearings that had, seven-figure dollar amounts originally attached, or no bail because they're originally perceived as so dangerous. They come out, they work with a public defender to challenge those allegations, and their lives aren't disseminated, which is what would have happened. And the last piece, Megan, this speaks to Lori's question on the chat, is what do you do if you don't have people that are there at arraignment or can go to the bail? What if they're homeless? What if they're just disconnected to what traditionally is thought of their community? Well, we have a natural community infrastructure in every city, and that's that movement. There's groups like Debug and community touchstones, religious institutions, youth organizations that are all anxious to play this role to fill that gap, so to speak, but haven't been invited to the party. And so what the Community Release Project is doing is essentially creating that community in the absence of the immediate understanding of it. So at that bail hearing, let's say someone doesn't have their family locally, we provide that community experience. So we say, well, this person won't be alone. Debug is here. We could be that community support for them. We'll help them in issues that get in the way of getting back to court, like housing or employment, et cetera. But also they'll have someone else with them. And so we wrap ourselves around that individual. We make it a community collective experience. And then we also see that it addresses the issues of the court. I mean, essentially what we're doing when we go to court from a community perspective is we're trying to take away any excuse a judge has to keep someone in that cage. So when they see someone that maybe doesn't have a family or community that's a parent, doesn't have a place to go to, what we say is, okay, we're going to find a place where they can live. They say, oh, we're not sure they could come back to court because they don't have a phone. Well, we're going to figure out how they can make sure they're notified of the court. They don't have transportation to court. Well, we're going to make sure that we help them find transportation to court. So any excuse a judge has to keep someone in a cage and ruin their lives, we're going to take away till the only option they have is to let that person out. So that way they could adequately and zealously advocate for their defense alongside the public defender.
Thanks, Raj. And we have had a number of shout outs for court watching in the chat box while you've been talking. We do have some resources in the University of Pretrial Library for anybody who's looking for a court watching forum or some examples of the way it's been done in different parts of the country if you're interested in getting that started. And Wendy also just shared a YouTube video of creating social biography packets for anybody who's interested in seeing more about that process. And then April, I just would like to invite you to add on to that question of for communities looking to break away from that, we've either got to have money and or risk assessment supervision dichotomy. What do you see as the opportunities and the solutions that are out there?
Yeah, absolutely. Actually, Raj, as you were speaking about what you all have created, I think it's the clearest example of when we talk about racial equity. How do we bring it about? If you go into any courtroom in America, and I'll use the example when I was a juvenile defender, very rarely would we ever see a white child come into juvenile court, but when they came in with exactly what Raj has built for communities who are farthest away from resources and power, right? They came in typically with a private attorney, with the coach, every question that the judge had about whether or not this issue was going to be addressed, they had a response to it, right? They had this team of resources because they had access to power and they had thought through all of the different resources that this person would need to succeed and to stay out of the cage, right? That's what we see. What Raj has built is actually the norm for people, let's just say people, white collar crimes. That's what the big law firms, white collar defense, that's exactly what they are designed to do, right? So when we look at this issue and look at what the options are, oftentimes I would tell people in, advocating for racial equity, I actually want for my client, people, mostly brown and black kids, I just wanted for them what was available for the white kid that walked in juvenile court, right? I wanted them to have access to resources and power and alternatives and ways to deal with behavior that is humane. So when you think about what he's doing, it's actually just building these systems of support that should be available to everybody in order to address these issues. And it's exactly the strategy that you see in well-resourced communities. That's exactly what they do when they show up for court. And so that's what it means to advance racial equity, right? That everybody has this opportunity to live and be free and deal with issues in a humane way. And so it really brought me back to my days of juvenile court and to just see what the private attorney brought in when it was a white child facing juvenile court versus how we had to fight as public defenders to pull together those same resources for our clients.
And that's such a perfect response to the argument of, well, why do we want to give special treatment to people who are facing charges? And why do we want to offer all these resources to somebody who's coming into court? That it's really just making resources that are available to so many other people in society without even a question, and making sure that it's there for everyone.
Yeah, and oftentimes I would tell people it's really not rocket science. It's what you would want. Like if you were facing the judge, would you want to turn around and see an empty courtroom? Would you want people to say it's no options, that you're beyond repair? So I think a lot of what we're building or forcing the system to reckon with, I don't think it's things that people don't know. I just think that I know that this amount of harm has been able to be done to Brown and Black communities because we actually think they deserve it. And that's a different question, right? Like, what does the system think certain people deserve, right? When harm is inflicted on certain people, specifically people of color, it's this notion that we can bear it, or in some way inherently we deserve it. And that's a real conversation about race in America, because I don't think when people see the brilliant model that Raj has created, it is very logical. It makes a lot of sense. So the question is, why hasn't this been done in the past? And I think that brings us back to this very painful answer that in some way we think these two systems of justice that we have seen operate in America for 300 and 400 years, that inherently people deserve it. And that's another conversation that I would love for PJI and others to have, because I think if we don't address that issue, then it's going to be very easy for people to make excuses for why we don't create equity within the criminal legal system.
Absolutely. I wish we had another hour right now to have that conversation, but we'll have to find another time to be able to explore that question more. But the last question I wanted to ask, I think, does come back to that resource point and how we're allocating resources. And as we're talking about defunding the police and what does that conversation mean? That one of many components of that is the question of where do we want our resources to be going in our communities, and where should they be going for safety for everyone, and being able to support people in times of crisis, and ideally to help keep people from being in times of crisis in the first place. And so I'm interested in both of your perspectives. And April, if you wouldn't mind getting us started on what would you like to see as part of those conversations of, if we start from the beginning, where should resources be going in our communities?
Thank you, Megan. I think someone posed a question in the chat box earlier on. I feel very strongly that the communities that have been disproportionately impacted by policing and the criminal legal system needs to define what public safety is for them, right? I think it's been this assumption, and I think we've seen the reality of what Black people have always known. The lynching of George Floyd, the only reason people believed us is because it was on film. But in our community, we have felt the terror of not feeling safe for many years. And oftentimes this conversation is from the lens of a person of color that's committing a crime and, making the community feel unsafe. But we also feel unsafe based on the actions of law enforcement. So when we talk about resources, I would say the communities that are heavily policed and most impacted by the system has to come up with their own definition of what public safety looks like for them. And I can tell you as a Black woman, what it looks like for me is that I want to minimize my contact with law enforcement. I want other tools in my community when there is a dispute and when there is an issue, a normal issue, that we can resolve issues in our own way and not involve traditional law enforcement. And I think law enforcement would agree that they're not equipped to deal with these issues anyhow. So the question becomes, where should those resources go? And I think they should go to organizations who already exist in my space, whether it's a faith-based organization or a neighborhood association, who understand me and they understand what it means for me to feel safe as a Black person in America. So I'm excited that we're in this space where we can reimagine, but specifically when you talk about public safety, we have to reimagine what public safety looks like for Black people. And I can tell you that this traditional response of more law enforcement does not create more public safety for us. So I'm just excited when the opportunity comes to actually listen to the people who's most directly impacted, what our solutions would be to where the resources should go.
Thanks, April. Raj?
Yeah, I mean, we've been out on the streets calling for defund the police for a long time now, and we've seen that exponentially grow recently since the murder of George Floyd. And yeah, we want a different understanding of what constitutes public safety and who identifies it, who articulates it, and what are the devices we'll go to and lean on to ensure public safety. The great irony, of course, is what the quote unquote law and order community has made synonymous with public safety is the same thing that threatens and jeopardizes and kills communities of color. And so we want, for example, the most obvious example here in San Jose, where we've had 18 police officer killings in the last 5 years of those that have been called for mental health crises. I'm talking about teenagers as well as adults. It's been a crisis. There's been a welfare check or a mental health call, goes to 911, police come in with AR-15s, and you have people killed when they're really calling out for help. What we need is a different number to call and a different response to show up that isn't armed, doesn't see community as a nail that they need to hammer, but people that are there that have the acumen and ability to actually deal with a crisis, to de-escalate and provide services that they've been calling for. So I feel like that moment has fully arrived across the country. It's no longer an aspirational goal. I think we're talking about real world application that should be happening today, if not tomorrow. But I think it's important, given the backdrop of the conversation, is that it extends beyond just the point of contact with police. And police obviously are the front lines of the system, but they're also not the only face of it. And we all know, for those that survive the police interaction, they're going to be facing most likely criminal charges, because the police will then cover their brutality by filing criminal charges on someone. And then that individual is facing the secondary assault of prosecution just for having the audacity of surviving the police altercation. And so what we need to do is not only defund police, we need to defund prosecutors and DA offices, as well as defunding jails and sheriffs. Because the reality is, for every George Floyd situation that we know about that haven't been caught on camera, the ones that we don't see are the ones that never elevate to the hashtag status, because the person survived the interaction, they're charged with resisting arrest or assaulting a police officer, and then they face years in prison. And we don't hear that story, but that is the story of pretrial justice, which means that we need to extend this idea of shrinking the impact and the role of policing also to the role and control that prosecutors have in defining public safety. And I will say, where I think that all lives from a movement, a community perspective, is in local courthouses. Our movement of abolition, our movement for racial justice has looked at police, it's looked at overcrowded prisons and jails, but there has been a blind spot, which is the machinery that both fuels police arresting, which is happening from prosecution, and also fills those jails and prisons. And so what community needs to do is bring that firepower, bring that intelligence to the courthouse, which has been designed to keep them on the outside, which allows that machinery and assembly line to continue. I think where that happens most clearly, in my perspective, is when community organizing groups that have been marching, protesting, when they combine forces with public defenders to look under the hood of the way that court is working, that arraignment, that bail hearing, et cetera, that's where they can make real proximate change. Community organizing, movement organizing has been on all the major issues like bail reform, like DA accountability, but it's been more macro. It's been legislative. It's been larger. What we could do is both. We can make the large systemic changes at the same time by working on the freedom of people that we know. So the movement is both massive to take on mass incarceration, but both proximate in the reality of someone is now home rather than locked in a cage.
Thank you so much. And that's a great note to end on. We have reached the top of the hour. And I'm sorry we did not get to all the questions in the chat box, but please feel free to bring those questions to the University of Pretrial. We had questions about risk assessment, which has been a big topic lately. And PJI has a new paper coming out. Also folks who raise questions about Indigenous communities and challenges facing people with addiction issues and homelessness. So we'd love to have the opportunity to continue those conversations as well. But April and Raj, thank you so much. I have enjoyed this conversation and learned so much from both of you, as I always do when I have the chance to spend some time with you. And this session has been recorded, so you can feel free to share it with anyone who missed it today. And hopefully we'll find some more time to be able to dive into some of the additional issues that were raised today. But otherwise, I hope everybody stays safe and well, and take care and enjoy your weekend.
Thank you.
All right. Thanks. Bye-bye.
Bye-bye.